Mumbai University. He has built an impressive career in criminal advocacy. Advocate Khan has an outstanding track record, which includes numerous high-profile cases. He has successfully defended clients in notable cases such as the Aurangabad Arm Hall, 13/7 Mumbai Triple Blast, Leila Khan murder, Pallavi Pushkayata murder case, Gateway of India, Zaveri Blast, 7/11 Triple Blast, Train Blast. He also deals with cases under ISI, NIA, MCOC, and UAPA. He is renowned for his dedication to justice and fair trials, influencing many young lawyers, leading a team of 10 junior advocates and 5 interns. He excels in trial cases, especially under Section 302 of Indian Penal Code. Additionally, he serves as a special public prosecutor in 8 cases at Alibag Court, appointed by Government of Maharashtra. Please join me in welcoming Advocate Abdul Wahab Khan.
Thank you, Advocate Mania. Requesting our resource person, Advocate Abdul Wahab Khan, to kindly take the floor to give us an insight about criminal trials and science of cross-examination. The floor is all yours.
Thank you for inviting me this morning. I'll treat all of us as a student. I'll use English, Hindi and Marathi to convey myself. Many amongst us are students, so I want everyone to understand. Every case starts with a crime. I'll come to the science of cross-examination a little bit later. I have to give the background. Every case starts with a crime. Unless a crime is committed, lawyers are not in picture. Once the crime is committed, the next step is FIR, first information report. First the FIR is registered, then the investigation starts, results in arrest. If there is no arrest, there won't be any defense. After the arrest, the investigation and charge sheeting. The case may be under TARA, POTA, MACOCA, UAPA, NIA, or SCST or Prevention of Corruption Act or some other special legislation. It may be under committal proceeding or where the court takes direct cognizance. It goes to the court and then the court frames the charge. Once the charges are framed in the case, evidence starts. Initially for prosecution evidence, it closes accused statement, then the defense evidence, if the defense so desire, then the argument and the judgment. Once the judgment comes in favor or against, either the aggrieved party goes in appeal, then the SLP. In special cases where the death sentence is there, suppose the Supreme Court dismisses the SLP, it goes in mercy appeal before the President. If the President dismisses the mercy appeal, even that can be challenged before the High Court or the Supreme Court. There are some cases. So this is what the strategy, the schedule of a case. Registration of a crime, disposal. In between, the role of cross-examiner, the cross-examination, the right and responsibility of a lawyer, of an accused comes from the state of charge till judgment. Before framing of charge, there is no right of cross-examination. Once the judgment is delivered, if the appellate court or regional court so desires, they can resend for trial for further evidence or additional evidence. Otherwise, this is the gap space where our right is there. To understand the importance of these rights, I'll give an example. Suppose, and with respect vegetarian, non-vegetarian, you are invited some guest, and you decide to serve them with a biryani. Veg biryani or non-veg biryani. everything is ready except for non-veg, the chicken or mutton, or for veg, whatever is the most tasty part of the biryani, that's lacking, that's not arranged, that's not come, that's not reached. And you have been asked to cook everything. आपने पूरा mix up करके मसाला करके everything you have made, but chicken or mutton is not there, or the main veg part is not there. And then at the end उसको दम दिया, everything is ready, you are asked कि अभी इसमें chicken डालो या अभी इसमें main part डालो. Will that be a biryani? It won't be a biryani. No one will call it. Cross-examination is like this. If that stage where actually you have to show your performance disappears, vanishes, goes away, is over, in your argument, whatever you will do, it won't be of any help. Therefore, the cross-examination is the most crucial part of any criminal trial. This is the only tool on this earth by which we can extract the truth. We can find out the truth. We can demonstrate that this is what the lie and this is what the truth. Now, the mental setup to become a good lawyer, to become a good cross-examiner. I'll give an example of twins brother. Now both have joined job at two different places, 9 to 5. Both the twin brothers leaves house at 9, returns at 6. One is tired, lazy, he's not interested in anything, he just wants to sleep, he don't want to have meal, he don't want to talk to anybody, he don't want to talk to his friend, he don't want to attend any call. He's tired. The other brother, the twin, is returning, and he's returning with singing song. He want to see some series. He want to make some calls. He chit chat with the family members. He want to go for outing. He want to go for gym. You will find that why these twin brothers, why they differ? They are doing the same work. The timing is one and the same, the salary is one and the same. The reason is that the brother who is tired while returning, there is no job satisfaction. He is not a fit person for that job. The other person who is returning like a very fresh, who is singing songs, who is mixing, behaving in a socially way, etc. Meaning there is a job satisfaction. So therefore, whoever is not satisfied in the profession, they can go for corporate or some others. Unless you are satisfied with this profession, don't be in the profession. Next thing, that always love your profession, always love your client, always love your cases. Unless you love your profession, your client, your cases, you can't progress. And I'm having personal experience of some of my interns when they joined me since beginning. अरे ये चोर, ये आपको क्या पैसा देगा? सर ये चोर लोग ये पैसा देते हैं, ये मर्डर किया, ये लूटा, ये. Always he was having hate for those clients. And 10 years, 12 years, 15 years, I had seen there at 0 level. You hate the profession, profession will hate you. You love the profession, profession will love you. Then the question comes cross-examination. You see, it is said that it's an art of cross-examination. I studied a book and it changed my mindset. It said it's not an art, it's a science. The result of science are accurate, or at least you can control the damage, or you can have the result up to the mark. For science, you can get mastery with hard work. Arts is a personal characteristics, personal feature. Everyone cannot become an artist. And to become an artist, it takes time. Suppose if you take that cross-examination is an arts. To become that sort of artist, it may take 5 years, 10 years. By that time, you may have killed so many persons. You know, the clients are engaging you, sir. Please defend me. He has the constitutional right. But you are not achieved that level of artism. You are not that standard of artist. You are on trial and learning stage with your own cross-examination. You are damaging the case. I'll give an example. It was under PETA, Trafficking in Immoral Practices Act. A victim of sex trade was under cross in the witness box, and the learned advocate was cross-examining. He cross-examined the victim and brought on record that she was forced to do the prostitution at certain place. She was served with the meal, with the cold drink and the drinks. She was shifted from one place to other place, from other to third place, third to fourth place. The shifting was from the main road, where the vehicular traffic was there, pedestrian traffic was there. She could see the persons, passerby, etc. She could see the policeman, etc., 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 etc. And for hours this cross was going on. And he said that you never failed to run away. This was the damaging question. He said, नहीं साहब, मुझे बोला था पुलिस वाले हमारे साथ है, भागेंगे तो गोली मार देंगे. Now you can imagine whatever he built, that she was freely doing all this, everything is damaged. Therefore, before commencing the cross-examination, what is required is that you must go through the full charge sheet. You must read the full charge sheet. That include final report, various panchanamas, FSL report, postmortem report, test identification, parade memorandum, other expert report. You should read the entire charge sheet. Without reading the charge sheet, you can't and you should not start the cross. You should read the entire charge sheet. Once you read the entire charge sheet, you understand this is what the prosecution case is. Then the next step, in the light of this prosecution case, you must take instruction from your client. ठीक है, murder किया, ठीक है. This is constitutional right to be defended. You inspire confidence in your client that he should tell you the truth. He should not lie. You should convince him that if he lies to you, perhaps your cross may damage his case. I'll give you an example. I got a case of a client. Against him, the charge was that he committed murder of his 6-7 years old daughter by strangulating in presence of his wife. In the FIR, husband and wife both were named. The wife was exonerated, she was a witness. And the case was that when wife wanted to protest, he showed the knife, the kitchen knife. After the arrest, under 27 of the Evidence Act, he made a disclosure statement, led the police party, the knife was discovered from the house. Bail was refused. His father was always pretending that the mother has committed a murder. There was some FIR or case was also registered, but he was not giving any detail. And the child was little bit mentally retarded child. You know, wherever she is, she used to do the urination or dirt, etc., etc. Not mixing up, etc. Not behaving like the of her age. But they said that the mother has committed a murder, the police has implicated the father. In FIR, both were there, police has exonerated one. Chief was over that witness, lady witness. She spoke against the accused. That he threatened with a knife, etc., etc. And the knife discovery was after 2 days of the arrest from the very same house. In the lunch time, second session, my cross was to begin. I got a time, so I spoke to the client. I said, "देख, मेरे को सच्ची बोल, तूने मारा है क्या?" He said, "नहीं साहब, मैंने नहीं मारा." बोला, "देख, अगर मेरे को सच नहीं बोलेगा ना, तो मेरे क्रॉस की वजह से तू मर जाएगा. मेरे को झूठ मत बोल प्लीज." तो बोला, "नहीं साहब, मैंने नहीं मारा." बोला, "पक्का?" बोला, "पक्का." Then cross started. I started on the cross के देखो आप घर में थे, इसको अरेस्ट किया. आपके घर पे कोई पुलिस नहीं आई, पुलिस नहीं आई। आपके घर पे कभी पुलिस ने तलाशी नहीं लिया, आपके घर से पुलिस ने कभी कुछ जब्त नहीं किया। नहीं साहब, ये पुलिस को लेकर आया था ना, कबाड़ के नीचे से चाकू निकाल के दिया पुलिस को। This was not in chief. You see the consequences of this wrong instruction. This was not in chief. And I was overconfident. I believed the instruction of my client. I was cross-examining. When it came out in cross, that his knife was the matter. Later on, I was so disappointed. I told them that I have defended honestly. I'll defend him honestly, but if you want, he can withdraw. Some assistant commissioner of police was writing one day, his father said, please give me the NOC. I gave the NOC, later on he was convicted for life. Therefore, first go through the entire charge sheet. Take instruction from your client. Use your practical experiences. The court can take judicial note when that stage is called upon. Before that, you must take introspection, your personal experiences. कि अगर कुछ रोड पे राइट होता है, what is the people's response? Accident होता है, what is the people's response? अगर when we go to the police station, what is the response of the police? If someone pelting stones upon some house, etc., what is the response of the residents, etc.? When the mob lynching occurs, what is the response? What is the most natural response? You use your brain, and then you amalgamate all these things. Charge sheet, instruction from client, and your personal experiences. Then, you see, always the criminal cases are sorted out, broken, won in your mind. The criminal cases are won in your mind. They are drafted in your office, demonstrated in the court. So before going to the court, you must have a theory in your mind. What is the theory of the case? What defense is the best defense in this case? You see, one way, the best way is to have a 100% clean acquittal. But you can't say that in every case I will secure 100% clean acquittal. You will come across many cases where clean acquittal is not possible. So if in those cases, if the gravity is reduced, like suppose a case is that of child rape and murder, a very young age girl is raped and murdered brutally. If proved, the man will be convicted for death. And that death, once convicted death, by trial court, it will be appealed up to the Supreme Court. So here, it's if the circumstances are very strong, instead of trying for clean acquittal, you can try for damage control. Try to bring the gravity of the case from death to life. If the case is of life, you can try from life to 304 part 1, part 2, or some other minor offences. That can be done by cross-examination, by demonstrating in the court, provided you have advanced strategy. Always remember to impress the presiding judge, to convince your theory of the case. You have the merits. On merits you can, and you have the fairness. If you can demonstrate, suppose on merits you may be having a weak case, but if you demonstrate to the presiding judge that on fairness you see, they are not fair, there also you can win. Like I was reading a death sentence case where the man was convicted for death by the trial court, by the High Court, it went to the Supreme Court. On one count, Supreme Court commuted a death to life. The trial court convicted the man for death because earlier he was convicted for some offense. And in appeal, in confirmation what was going on, The investigating officer filed an affidavit, produced a judgment, and the High Court observed that this is what the record is. That was disturbing to the Supreme Court. How it can be? And that was the only ground, nothing about the merits. It was reduced to life. So, while deciding the fate of the case in your office, in your mind, before proceeding for cross-examination, you see that you should contest the case on merits as well as on fairness. Further thing, when the trial goes on, many times, with respect, I don't want to criticize anybody. Sometimes we find it very difficult, ourselves as a defendant, very difficult situation. We can see that a learned prosecutor is putting a leading question, giving hint to the witnesses. Like for example, the witness is asked, is this the same ring? Witness says, no. What? Kya bola? You get frightened. No, sir, yahi hai. You say, no, sir, you see, he gives a hint, he is threatening. No, sir, he did not understood the question, that's why. If you insist more, you say, okay, sir, you do one thing, you record both. This is not the ring, I again say this is the ring. Now, in between whatever has transpired, it's not a matter of record. You see, the witness is given one answer. That favors your case, your theory of the case. And in fraction of second, the witness has changed the answer, contrast to earlier answer, which is against your case, against your theory. When you are insisting that first has to be recorded, it will be objected, saying no, he did not understand the question. But record should show that he did not understand the question, that is what the witness is. That never will come on record. You have to learn to tackle this situation. In between these two answers, what has transpired, please bring it on record. File a proceedings, file an application. This is the thing, this was asked, this was answered, this is not recorded. If a leading question is asked, suggesting a fact, if you object, or if the court may say, okay, I have not aligned that question. Yes, Mary. Go ahead, ask that question. Now you see the lead, by asking a leading question, prosecutor has given hint to the witness. Like for example, कितने लोग चाकू से मार रहे थे? Presumptive question that more than one person was there. So sir, it's a leading question, sir. There is no foundation. This is not an introduction. This is not an admitted fact. Please record it as a leading question. The witness got the hint that more than one person was assaulted with knife. The presiding judge says, no, I am not recording the question. We'll proceed ahead. Yes, mister. हाँ फिर क्या हुआ? फिर क्या हुआ? फिर क्या हुआ? कैसे मारा? The witness had an idea. सब दो लोग के हाथ में चाकू था, उसने मारा. But now that stage is over. You can't say, sir, now recorded. He around 5 questions earlier he has asked the leading question. You ought to have objected and insisted, or upon refusal would have filed a pursuit to the court, an intimation in writing to create a record that this was the question, leading question asked to the witness. In one of the matter, with respect, I don't want to name anybody. It was very, very, very serious, highly contested matter. The witness was from US on video conferencing. One of my interns said, and trial used to start 7:30. Full of media person in the courtroom with the police officers, ATS officer, etc., etc. One of my interns said, sir, learned prosecutor coming out from the office of the learned judge. The chief was over. I was asked to cross-examine. I said, sir, the learned prosecutor was at your office. He said, yes. So I am giving process. He read the process. He started firing me like anything. He fired upon me. This is a backbiting. This is a back. I said, sir, is this a backbiting? No, this is a backstabbing. Even you have come in my chamber. You want to spy my record. I said, sir. And then he was not allowing me to defer the cross, this, that, etc. One senior lawyer was there. He requested, sir, allow him to have time. They said, okay, I am allowing the time deferring cross. Then the senior lawyer, he He said, वो अर्जी तो withdraw कर ले. I said, let me think over this time. तो दे मेरे को थोड़ा सोचने तो दे. I'll apply my mind. Okay. Break was given. I went out. I made a call to one of my friend. अरे बाबा ये ऐसा ऐसा बोला मिस्टर listen. आज अगर तूने ये अर्जी withdraw किया, whole life you'll be going down before the judge. सारी जिंदगी उसके सामने झुका रहेगा. और आज अगर ये अर्जी विड्रॉ नहीं किया, he can't raise his head. I went to the court. I said, sorry, arzi is leaked in the media. I can't withdraw. I don't know. That appearing on record, that matter is pending. The judge is still there. I don't want to name anybody, but you must have that much courage, that much guts to bring these things on record. Now, the next question. The science of cross-examination. I have said you must go through the charge sheet, you must take proper instruction, you must apply your mind, use ground reality. You must prepare the chapter. Chapter method of cross-examination. Now, how to prepare this chapter method? I'll give an example. 27 disclosure punch witness you have to cross-examine. Now 27 is a special provision where the statement made by accused while in police custody, if coupled with some discovery, it is admissible. Law doesn't say pancha's presence is required, but the police uses that two panchas were present and etc. Now suppose a weapon of assault is shown as discovered under this particular panchnama. You have to prepare a chapter. Now you see, you find out what are the basic ingredients of 27 discovery. Discovery, rediscovery. Discovery is admissible, not rediscovery. So you have to draft a chapter to show whether you can demonstrate that this was not a discovery, it was rediscovery. Fact not known, fact already known. If the place of hiding the weapon of assault is already known, it is not admissible. You must draft that chapter. Discovered fact accessible to the entire world, except to the officer. If you can demonstrate it was accessible to many pedestrians, it was lying in open public place, that is also not admissible under the eyes of law. So you can have a chapter on that point. Then the discovered items and its relevancy with the facting issue. अभी वो firing से murder है, a firearm is used, a discovery of knife or sword, how it is relevant. So you have to find out that. If suppose the discovered weapon is a firearm and the bullet tallies with the bullet returned from the body of the deceased, is a very strong piece of evidence. It can't be planted by the police. How they got access to such firearm? So you have to demonstrate its relevancy. And then the panchas, the regular panchas, etc., contemporaneous record in the form of station diary, logbook, etc. Then delayed disclosure statement. उसको 1 तारीख को अरेस्ट किया और 12 तारीख को डिस्कवरी हो रहा है. Then in between thorough voluntary nature. You know, this is also one of the ingredient of 27 disclosure, voluntary nature. So you can have a chapter on voluntary nature. एक को अरेस्ट किया, उसको पूछा, बातचीत किया, he was telling the truth, everything truth, he was not hiding. So you see, these are the questions where whatever the answer he gives, the officer or the puncher, especially officer, he was telling all the truth, he was not hiding anything, he was cooperating in investigation, he was not concealing anything, he admitted the guilt, etc. All these things. His accused statement was recorded. You were interrogating a number of officers. Each officer was putting question. Now, if you take this for hours together, for days together, it vitiates the voluntary nature of disclosure. There are Supreme Court judgments which say that such sort of grilling interrogation vitiates the voluntary nature. So, to break this 27 disclosure panchnama, you have to prepare chapters, divide into sub-chapters, and then in chief, when the evidence goes on, what are the answers? They comes in the four corners of some chapter or the other. You have to develop in this way. Like for example, and then this is one thing. Chapter, you have to prepare the chapter. Second, you must study the subjects in a proper way. I'll give you an example. In olden days, where there were no boundaries, there used to be war in between the tribals, the communities, for various reasons. There used to be two types of people. One, in peacetime, they used to sharpen their weapon. Peace means there is no war. They used to sharpen the weapon. The other, in peacetime, they used to enjoy. They used to sleep. This sleeping used to be the sufferer during wartime. Because when the wartime comes, they don't get a chance to sharpen their weapon. Meaning thereby, don't wait, okay, terror trial aayega, then I will learn the law. Murder trial aayega, then I will learn the law. Narcotic case aayega, then I will learn the law. You are in peace time, you have the time, you are at junior stage, you don't have that much brief. Sharpen your weapon, learn the things. Science of voice identification. How to break that? Science of ballistic expert. How to break that? Science of DNA. How to break that? Test identification parade is also one of the piece of evidence. How to break that? Dying declaration, one of the piece of evidence. How to break that? Confession under special enactment like Tara, Kota, Makuka. It is before police officer admissible. How to break that? Confession under 164 record the judicial officer. How to break that? These are the specialized subjects. You must get mastery over these subjects. Voice identification, DNA, ballistic expert. Don't wait that case of that sort will come. Because what happens, the day when the case of that sort will come, you will demonstrate, you will have a series of that sort of cases. Like for example, you are the newcomer in the profession, a commercial quantity का narcotic case है आपके पास. You are defending a client, and you are defending up to the mark, and you are getting a favorable order. Before that verdict, you will have a series of that sort of cases. You are not permitted personally to advertise. Your way of performing the court is your advertisement. Your client will advertise for you in the prison. And you will have a series of cases of हमारा 5 किलो का, हमारा 2 किलो का नहीं, आपने काम अच्छा किया है. So therefore, in peace time, where you are not having that much brief, where you are not so much occupied, you sharpen your weapon as much as you can. It's not needed that one should be from the science faculty or the commerce faculty or the arts faculty. Try to understand the things. Do the research. Don't go for the available book. Try to find out the books which are not available. Try to go online. Try to see the view online. Try to research. Get the mastery. And when the case comes, see how you can accommodate that with your case. Then second thing, when studying the case, you should know which are the circumstances which are incriminating. This is what I am giving the background before I come for the cross examination. You must know the background of the case. Then you should know if the FIR is lodged against unknown person. It doesn't incriminate you. Therefore, don't waste your energy on that non-incriminating substance. Like FIR lodged against unknown person. Now, you have to be careful. It's not incriminating you. But someone has died that you can dispute. Inquest Panchnama. Deceased close Caesar Panchnama. Arrest of the accused in compliance with DK Basu. Caesar is closed without any blood stain, non-incriminating. These are the things you have to find out. They are not incriminating. Don't waste your energy on that. find out which are the things which, for example, the parade, test identification parade is held, where none of the witnesses identify your client. So there is no need of cross-examining such things. Find out from the record which are the things which favors your case. Admit under 294 is the old code. In new code, you admit. The things which favors your case. For example, the history given before the medical officer. That I am innocent, I have not committed any crime, etc., etc., etc. Or the first complaint made before the remand officer, learned magistrate. So, from the charge sheet, admissible piece of evidence, whatever the admissible piece of evidence which supports your theory of the case, which supports your defense, you should not shy to admit at first. Find out which are the things which incriminate you. Then on that incriminating facts, you prepare chapters for cross-examination. Like there are 2 eyewitnesses in a murder trial. We have to prepare the chronology. This is what the date of offense, the time of offense. This is what the time when crime was intimated to the police. This is what the FIR was registered, the inquest, the spot, this, etc., etc. The arrest. After 5 days, the first witness comes. The best chapter would be the delay in disclosure, where this first witness was, and second witness after 10 days. So prepare a chapter on these incriminating facts. There is one school of law of cross-examiner which believes that if one target is achieved, suffice, and it doesn't bother to go to another chapter, another issue. If you can falsify a witness on one count, with my experience, with my understanding, if you are getting 4 ways, 4 options, you must utilize all that. You don't know which issue, which chapter, which method would be more convincing to the trial court, to the appellate court, to the special court, to the revision court. Like for example, the regular punch witness. This is one chapter. Then, having given inconsistent answers in earlier proceeding is another chapter. The inconsistency with present evidence is a one chapter. Disrespect to the truth is another chapter. Avoiding to give answer is another chapter. So whatever you can develop in a chapter way, separately you demonstrate on record. The cumulative effect would favor you, the individual effect would also favor you. You don't know which portion, because no, ultimately the case has to be decided by the judge. So you should find out which are the incriminating things. In many times while conducting the trial, it so happened that the incident is of 1st March. Witness goes to the police station to 2nd March and he says that it was 2nd April. It is his case that he has gone on 2nd April. Now if you leave it as it is, saying yes, we have achieved chief itself, it has come to 2nd April. Perhaps the court may say it was inadvertence. It was slip of tongue. It was over-exaggeration. It was misunderstanding. But as a cross-examiner, you can utilize this. Instead of 2nd March, if 2nd April has come, you develop this 2nd April in a chapter way, asking 1,000 questions, that tomorrow they should not say 2nd April was slip of tongue. Because one sentence, it may be slip of tongue. It may be inadvertence. But if you ask 100 questions on that topic, then it don't remain slip of tongue. It becomes a fact, a complete chapter. And the stage will come, even this witness doesn't dare to change it. Now, with regard to the cross-examination, there are 3 golden rules of cross-examination. The basic principle of cross-examination. We should never forget that. This is the case of the prosecution, case of the defense. I'll explain this and the difference. When accused is arrested, the police officer makes submission, sir, serious crime, repeated offender, see the brutality, see the victim, see the terror, see the case diary. And the defense is known, sir, he has the family, sir, he is falsely pleaded, etc., etc. And judge says, okay, police custody. Even if you say, I was not there, I was at some other place, sir, falsely pleaded alibi. Alibi is your defense, that will come after 313. Now I have to see the prosecution case. So till the stage of charge, whenever you file the bail application or whatever before the trial court or the high court, etc., the prosecution has the case. So it's our case. And that case is weighed by the court whether to grant bail or not. Defense is not considered. Like for discharge also, if you file a discharge application, defense can never be considered at discharge stage. You have to demonstrate from the charge sheet. So, till charge is framed, prosecution has the case, you have no case. Once the charge is framed, prosecution doesn't have the case. You have the case. Just try to understand. Till stage of framing of charge, prosecution has the case. Every time they will demonstrate. Once the charge is framed, prosecution doesn't have the case. That's the reason when the examining chief is late, they say, then फिर क्या हुआ? फिर क्या हुआ? They can't put a leading question. This is the basic difference chief and cross. In cross, you can put a leading question. You are permitted to put a leading question. That is your right. That can't be discarded or denied. Prosecution cannot put a leading question. Till charge, they have the case. कि 2 आदमी ने 2 तलवार से 4 बार मार के मर्डर किया. In chief, he can't put, ये 2 आदमी ने मर्डर किया, he can't put in that way. He said, what happened, where you went, what you saw, who was there, what he did, how many times. So, he can't suggest the answer. Meaning thereby, when the trial starts, prosecution doesn't have a case. They can't go for leading question. You have the right to put leading question. And this we have learned from our practice. Now this is the basic difference. In spite of this right being in your favor, if in cross you are asking to the witness, फिर क्या हुआ, फिर कितना बजे हुआ, फिर किधर गया, फिर कौन आया, फिर meaning thereby you are doing the work of prosecutor. Where, when, why, whom, how, all these question mark, open-ended question which are permissible only in chief. If you are putting in cross, meaning thereby you are killing your client, you are going close to conviction. You are damaging your own case. Sometimes, for record purpose, yes. But you are permitted to put leading question. Instead of that, you are putting open-ended question. कब, कैसे, कहाँ, किससे, etc. So, meaning thereby you are giving full opportunity to the witness to explain his theory of the case. Whereas, legally, after charge, you have the case. Charge sheet तुमने देखा है, you know from the charge sheet what favors you. You have taken instruction from the client, what favors you. Your ground reality, your experience, and you know how the offense must have occurred. किसने किसको पहले गाली दिया? जो मर्डर हुआ है, every murder it doesn't take place गया और मार दिया. मर्डर से पहले झगड़ा होता है, झगड़े में गाली गलौज होता है, गाली गलौज में धक्का बुकी होता है, धक्का बुकी में पब्लिक दोनों को सेपरेट करती है, सेपरेट करने में दोनों एक दूसरे के आंख में जाते हैं, दोनों एक दूसरे के आंख में जाने दोनों एग्रेसर रहते हैं. This is what your case should be. instead of using these ground reality and instruction of your client, if you are giving an option, because he has been tutored to say one side, he will explain his part of story. Therefore, we should know the difference between chief and cross. Then, before commencing the cross, you had seen the conduct of the witness in chief. Many times, the witness feels that actually this is something else. He stick to his case. Language barrier, pronunciation barrier, understanding, tutoring, pressure, threat, illiteracy. There are so many things. वो 5 मिनट 10 मिनट के एग्जामिन चीफ में you can have a psychological profile of that witness in your mind. ये विटनेस से मुझे ऊंची आवाज में बात करना रहेगा, सबमिसिव बन के बात करना रहेगा, इसका दोस्त बन के बात करना रहेगा, इसका एडवर्सरी बन के बात करना रहेगा, उसके गांव का लैंग्वेज का प्रोनाउंसिएशन में बात करना रहेगा, हाईली क्वालिफाइड सोफिस्टिकेटेड बन के बात करना रहेगा, टेक्निकल में बात करना रहेगा, मेरिट्स में बात करना रहेगा. यू हैव टू मेक अप योर माइंड लाइक अ नॉर्थ इंडियन भोजपुरी स्पीकिंग विटनेस इफ कम्स टू गोवा. हम तो कुछ देखा नहीं भैया. अब इफ यू आस्क इन दैट वे, he will feel that he is from my village, मेरे गांव से ही है. तो then he will, in one of the matter, it was a firing murder. Learned prosecutor Mr. Kulkarni, long back, around 15 years back, it was a robbery murder case. The witness was from UP. He was a security man. The case was that it was attacked, the firing was made and then one person expired. So prosecutor took 2 hours. मका झाला, पुढे काय झाला, साफ समजा नहीं. So he is from North India, he don't understand language. The prosecutor was speaking Hindi, but it was Marathi pronunciation. And this witness was finding it difficult. It took 2 hours for 2-page chief. And I started the cross. I said, "Hey, भैया सुनो, ना समझे तो बोल दो." तो he felt that अरे गाँव वाला. He gave all favorable answer. Within 15 minutes, 4 pages answer, every favor. The judge was VP Mantri. I remember. He said, "Mr. Khan, what is this?" I said, "No, sir." He felt comfortable. This is a human psychology. This is a human psychology. So, at the time of chief, you must remain present, you must take a note, you must have gone through the entire paper. We should understand the psychology of the witness. What sort of cross-examination? And then the strategy. The best or the worst. That's your prerogative. That's your discretion. Some chapter may be the best chapter. Some chapter may be the weak chapter. Now, among those chapters, to cross-examine a particular witness, find out which are the chapters where the witness cannot run away, where the witness has to admit. Like, for example, at 27 disclosure Panchnama. In police station, accused said, "I want to give a voluntary disclosure." Therefore, we asked him to stop. We called 2 panchas. The accused made a disclosure statement. "Sir, I committed a murder, weapon of assault. I have concealed at around 10 km distance. I am ready to point out." We recorded a memorandum. We made arrangement of vehicle, obtained a signature on the memorandum, left the police station. He led us to a particular place. It was concealed. He produced before the panchas. We took the same in custody. We found the blood stain. Further portion of the Panchnama. Then we returned to the police station, read all the content of Panchnama to the police station, obtained their signature. What does it mean? Meaning thereby memorandum and discovery both are in police station. Therefore, this witness cannot run away from the factum that discovery is also in the police station. Panchnama was signed, the final part was in the police station. It was read out in the police station. Law says on the spot itself. There was nothing which prevented the police from getting signed on the spot itself. So therefore, this is the chapter where you can develop, we can demonstrate that this is the thing happened in the police station. He can't run away. And when you signed, the weapon was in your presence. It was visible, lying on the table. Meaning thereby sealing, labeling, packaging gone. It's open to tampering. The IO is never going to admit this. Okay, it was done in this way. So therefore, among those chapters, you find out which are the chapters. For example, delay. Suppose the witness 161 statement, eyewitness's version has come on record after 10 days of the incident. Now he can't run away from that. But if you can demonstrate the very first day he was available in the hospital with the injured, he is witness to the arrival of the police, he met a police officer, he made a disclosure statement, police made an inquiry with him, he gave his identity. And if you develop that very same day, his statement was recorded and you say, sir, this is suppressed. That was the first statement, first in point of time. And after 10 days, a belated state, a tailored version, his credential diminishes. So you should find out which are the best way to attack. Of course, you can start from the weak points also. But advisably, if you can have a good point, you can attack from the good point. Then, the first principle of cross-examination, always put a leading question. This is the first golden principle, internationally recognized. I am a local lawyer, but I can assure you this is internationally recognized. If you do the research, you will find very funny video. I was just walking there on this cross, what is the material? So one of the lawyers will give, witness को control में लेना है. Witness डरना चाहिए. But that is not the scope of cross-examination. The judge is there, you should offer it of the judge. ऊंची आवाज में बोलना चाहिए. No, you can't raise voice greater than the voice of the judge. It is disrespect. The judge knows he is taking a mental note of your demeanor. Using high jargons, उसको bounce जाएगा, वो आंसर ही नहीं देगा. Or if you use high jargon, every question will be explained to you by the judge. The very effect disappears, goes away. So the cross-examiner should know his limits. He must be humble and submissive to the court. Strong, confident to the witness. Should demonstrate he has command over the subject. All questions should be leading questions. See the psychology of this leading question. While putting a leading question, you are suggesting a fact to the witness. 12 बज रहे थे, वो हाँ बोलेगा ना बोलेगा. 12 बज रहे थे, तू अकेला था, 4 मील गया, अकेला आदमी था, हाथ में छुरी था, छुरीधार था, स्टील का था, हाथ उठा. Leading question. Now you see the effect of psychology. Here the witness is not required to use his mind. In chief, you ask me, फिर क्या हुआ, फिर कौन आया, फिर कैसे आया, फिर क्या देखा. He is using his mind. He is memorizing whatever is tutored or he had seen. Whereas in cross, you are not allowing him to rememorize, to recollect. You are suggesting the fact in a leading form. So, ready-made fact, human mentality, human psychology, directly accept. Because he is not required to use his mind. Now, if you develop this habit in the witness, throughout your half an hour's cross-examination, 15 minutes cross-examination, then he loses the psychology or the tendency of dodging the answer. Because, the best way is to, हाँ बोल के बोलो यार, क्या उसको मतलब, if he want to explain, then he has to give few more sentences. And simplicity, you are giving the answer, you are giving the facts, you are putting leading question. So you are putting him in the comfort zone, where he is not required to his mental faculties, where he is not required to recollect the events, tutored or otherwise. सचमुच में देखा है या सिखाया है, he is not required to recollect that. He has to ready-made है, लिया और चल दिया. उसको पकाने का, सोचने का, ग्रिल करने का उसको जरूरत नहीं है. He will say, yes. So, first basic principle of cross-examination. All questions should be leading question. Now, while putting a leading question, we should not admit the case of the prosecution. The prosecution case is that इसने 4 बार वार करके मर्डर किया. You should not put a leading question in that way कि इसने 4 बार मर्डर करके वार किया. हाँ बोला then finish. उसने बाद में मारा, आपने पहले मारा. Because the answer will be, it is correct to say that accused stepped 4 times and killed the man. See that? So therefore the leading, you should put all leading question except the case of the prosecution. The second, the golden principle. Perfect one question. This is a golden principle. Perfect one question. Simple question. It should not be a compound question. It explains your theory of the case to the maximum extent. If you put a compound question, the learned prosecutor may point out, yes sir, see this question was put compound. रात के 12 बज रहे थे और आप खाना खा के वहां पहुंचे थे. It's a compound question. It may be that 12 o'clock he reached. It may be that he reached after dinner. It may be he reached without dinner. These are two facts in one question. Part may be yes, part may be no. Now if you are putting this compound question, you are allowing the witness to run away. The answer is which he decides to give. Therefore, you should always put simple question, per fact one question. Evidence may be little bit lengthy, as if you are cross-examining too much. But this is what the principle is. You can't put a compound question. Per fact one question. It will be clear on record where you have to work hard. Like for example, in an accident case, you are asked to defend the client. You are putting one question per fact. Into the night time, yes. It was 12:30 a.m. Yes. It was pitch dark, yes. It was main road, yes. You are the driver's seat, yes. It was so and so car, yes. You started so and so, yes. From so and so point, yes. You reached so and so, yes. The road was empty, yes. The speed was so and so, no. Yes. So now you should know, okay, this is what is on the speed this witness is disputing. Rest of the thing, you got an admission. Now you can demonstrate through the mouth, you can further cross-examine this witness on this point of speed. You can take it from the investigating officer, you can prove it through the defense evidence. Okay, from this stage to this stage, it takes this much time for this speed. Otherwise, one can't reach. This you are dead with. So therefore, per fact, one question will guide you, and it will be a comfort zone for the witness also. Facts are very simple. The presiding officer will understand what do you mean. The witness will understand. And by bringing a record series of such questions, you are giving the whole scenario on record that this is the things, admission. And with all this admission, after reaching one stage of the speed, witness cannot say, "Nahi sir, main gaadi mein tha hi." So the second golden principle of the cross-examination, per fact, one question. Third golden principle, from generalized to specification. From generalized to specification, you see, some learned advocate, they start, मेरा ऐसा कहना है तो झूठ बोलता है. This is specification. मेरा ऐसा बोलना है 5 तारीख को ये काम हुआ ही नहीं. This is specification. You must go from general, become more specific, more specific, more specific, more specific, and then to the ending point. Now, if you follow this principle, you see the witness, the category of the witness, he may be a real witness. In fact, he may have seen the incident, or he may be a tailored witness, he may not have seen the incident. If he is a real witness, he had seen the incident and he can answer your questions. If he is a tutored or tailored witness, in that way he can answer the question. But in any of the eventuality, this chapter method of cross-examination, leading question, per question one fact, generalized to specialization, charge sheet, client inspection, your experience, no one can tutor to the witness. They may tutor their 161 statement. They may tutor their theory of the case. Therefore, generalization to specification. These are the three golden principles of cross-examination. Other than this golden principle for cross-examination, a cross-examiner should always be mindful what question he has to put. In each question, what words he has to use, and the words should be arranged in what sequence. Always remember, this plays very important role. And then, which word you should emphasize, which word you should not emphasize. When cross-examining the witness, what is the language? Selection of particular words, arrangement of that words, and among those words, emphasizing particular word, pressing certain word, blowing certain word out of proportion, sounding with some word, downplaying with some word. It gives altogether different meaning. One fact, if you want to extract from out of the witness, you can question him in 10 different ways. You have to find out which is the best way. Then about use of non-incriminating material in your favor. In 489 DC cases, counterfeit currency note cases, or NDPS cases, or prohibition cases, not in Goa but in other prohibition cases, or the cases where the whole case is based on two punch witnesses, one police complaint and an eyewitness. That's all. They decide the fate of the case. Here, you can find out some witnesses who are otherwise not incriminating you, but you can use for your advantage. I'll demonstrate. In around 8 to 10 cases under 49C, I got an acquittal on this count itself. See, whenever the charge sheet is filed, and normally the learned advocate don't disclose that this is how, but the charge sheet is filed, the complaint is there, eyewitness is there, punch is there, IO's final report is signed, then some carriers are there. In NDPS cases, in 49BC, carriers who carries to FSL article, etc., in seal condition. In every charge sheet, those carrier statement is there under 161. That mala RO officer ne bola, he gave the article to me for FSL. I went there, I deposited, I returned the letter of the IO. This is the letter. This is what the evidence is. Non-incriminating FSL, we can't dispute. But you can use this in a best way in your defense. You see, each constable is demarked with his statement with a buckle number. And if in a case there are 10 panchnamas, suppose 4 accused are there will be 4 discovery panchnamas, 2-3 search panchnama, 2-3 arrest panchnama, you will find this buckle number is written in 5 panchnamas. Meaning that by this carrier who is a formal witness, not a formal witness, he is witness to those items also. Now, actually, what happens, you see, when the officer write the panchnama, many times, they just, put the buckle number or name of the officer. That police team, hey, hote, whatever. Now, that man doesn't know. He never knows. He has never gone there. Now, therefore, when this carrier come to the court, he read 161 statement. On this date, IO gave me the article, I carried the FSL, on that date I returned the dispatch letter. That's the evidence. Now, if you are asking, like in many cases I started across, that sir, today you read your statement. He said, no. You are giving evidence on the basis of reading of statement. No. You are giving evidence upon tutoring. No. You are not giving evidence on the basis of memory. No, I am giving from memory. Okay. Where you were on 10th October. So I don't remember. You are not in the position. I don't remember. You can identify the article. No, I can't identify. You have seen the article. No, I have not seen. They were wrapped, they were packeted in your presence. No. They were seized in your presence. No. They were discovered in your presence. No. No, none of the accused produced in your presence. No. So therefore, if discovery panchnama shows you are present, it will be a lie. Now you can't deny it. And no harm, you show him the discovery panchnama, you see your buckle number, you show him that. Your name is also shown. Your surname is also shown. Yes, silent. Don't go ahead. Now he has read the discovery panchnama, he knows he has already denied that. So in this way, those formal witnesses, which are not incriminating, you can use in your favor. In a similar way, when the charge sheet is filed, in many cases, you will find because of over smartness of the investigating officer, or just to make fun or show off, etc., they record statement of some of the family members of the accused in the charge sheet, or some of the friend or well-wisher of the accused in the charge sheet. Now, suppose if you have theory of the case and you have demonstrated since beginning, you can prove that through these witnesses. For example, suppose in a case you want to have a right of private defense, sudden and grave provocation. You want to prove and establish that the victim party were the aggressor. To the relatives of the victim or the witnesses, you had given this suggestion. To some extent, you got an admission in your favor. Fortunately for you, unfortunately for the prosecutor, if they dare to bring some of the relatives of the accused in the witness box, and of course, is a prosecuting witness, if you establish your theory of the case, this is how the things has happened. This is what the incident occurred. That will damage the case of the prosecution. You should never miss such opportunity. Because the Evidence Act, this law, speaks about relevancy and admissibility of the questions or the facts. It doesn't say which facts are relevant or limitation on their part. Some provisions are inclusive in nature, complete. This is the only limit you can't cross. Some exclusive, you can go ahead of that. So therefore, you can demonstrate that we are not bound to restrict to chief. We are concerned with relevancy and admissibility. If foundation is laid down that the witness was present at the time of incident, he has seen the incident that has gone on record, then all subsequent question becomes relevant. The next few techniques. Always remember and keep in mind, you can't win the case by lying to the court or to the witness. You can't win the case by threatening to the witness. You can't win the case by misguiding to the witness. You can't win the case by distracting the witness. You can't win the case by browbeating the witness. You can't conduct the cross. उसको झूठ बोल के, misguide करके, distract करके, threat. You can't. You are an advocate. You have your limitation. With your performance, well-recognized techniques, chapter method of cross-examination, following golden principle of cross-examination, understanding the law, you can demonstrate to the court. You see, certain part of cross-examination, if you follow the technique, well-recognized technique, you can develop your case in a more impressive way. One technique, I just give illustration of 3 techniques. One amongst them is juxtaposition. This is an internationally recognized technique for cross-examination. Now this juxtaposition, what you are doing, you are cross-examining a witness. And you are demonstrating series of 2 parallel facts. And at the end, even if witness disputes, court will say no, he is lying. For example, you are demonstrating to the witness that, sir, in the year so and so, you were working for so and so as a security guard. This was the timing, this was duty, this was responsibility. You attended duty, you committed theft, you are prosecuted, you are convicted, you pleaded guilty, you undergone the sentence. Now juxtaposition to this. So in this case, you joined the duty as a security guard, duty was so and so, this was the responsibility, you are having the charge, everything was accessible to you, you committed theft. Even if he denies, in juxtaposition to earlier admissions, his previous conduct, the jury will infer. Then, loop method. See, this loop method, this technique, is that you are cross-examining, getting one admission in your favor. Is a method, is a technique of flag hosting. See, while cross-examining to certain facts, you have to put the flag. You want it to be seen from long distance. With this loop technique, you are getting one admission. And with one admission, you are developing other 10 facts, which will be contrary to the case of the prosecution. Like for example, the time of incident 10 p.m. The charge is that the offence was committed at 10 p.m. And from the witness, you are developing a case at 10 p.m. he was at residence. This loop 10 p.m. you are developing at 10 p.m. you are at residence. And at 10 p.m. you are at residence with your family. And at 10 p.m. residence you had a dinner. And at 10 p.m. at your residence you had a guest. So with this loop you are developing a complete chapter which falsifies his presence at the crime scene. So these are the things one should remember while cross-examining. Now on each topic, voice identification, hearing. Now you see, you should know what are the circumstances normally used in a criminal trial. There are few circumstances. Exceptionally, the cases goes beyond that circumstance. Evidence, piece of evidence. Confession, extrajudicial confession. you must get mastery how to break this. Confession, extrajudicial confession. Then dying declaration. Then test identification point. Then ballistic expert, the voice identification expert, the DNA evidence, the last seen together theory, the previous conduct, the subsequent conduct, the motive. If you get mastery over these pieces of evidence, in a trial, if you demonstrate, you can reduce the severity of the crime. I was conducting a trial for last 12 years. Recently, my client was convicted for death. It was a 6 murder case. The charge was 6 murder case. Parvez Iqbal Tak. The deceased family members were the film actress Laila Khan, who acted against Rajesh Khanna in Wafa and Beka. The special prosecutor was there in that case, Ujjwal Nikam. The charge was that this accused Parvez Tak, who was the third husband of the deceased, was insisting upon her stepdaughters for go to Dubai for prostitution, was forcing and harassing them. That was the motive suggested. He kidnapped them from their residence at Oshura Sunshine Apartment, Mumbai, took them to their bungalow at Lonavala, committed their murder and robbery, concealed their body, disposed of their vehicle and disappeared along with the co-accused. That was the case against him. Around 40-45 witnesses during 12 years were examined. My defense was a total denial. Although the result was not as it was expected, but ultimately I can't lose sight of the fact that it was a 6 murder case. What I succeeded is this. For conspiracy, judge is acquitted. This is conspiracy is not proved. For kidnapping and robbery, judge is acquitted. For motive that he was forcing the girl for prostitution, judge is acquitted. Then one more discovery was there of some articles, incriminating article, weapon of assault, even that is judges discarded. What judges considered that the bodies were retrieved upon his disclosure, and then he instructed some of the person to dispose of the vehicle. And he has been convicted for murder and disposing of the evidence for death. I am quite hopeful the High Court will consider this and will succeed in proving his innocence. Because once this motive, the conspiracy goes away, it becomes a simple murder. He committed murder. Why? No evidence. Therefore, in a criminal trial, whatever the piece of evidence which you can damage, in a criminal trial, there are so many pieces of evidence, eyewitnesses, discovery, extrajudicial confession, motive. So whatever you can damage, by damaging that you can demonstrate with the rest of the things that the case is not proved. Last but not the least, one judgment, Sharad Bindichan Sarda versus State of Maharashtra, is a landmark judgment because we are having cases of direct evidence, circumstantial evidence. This case is for circumstantial evidence. Sharad Bindichan Sarda versus State of Maharashtra. Now this is a landmark case where their lordships have said that these are the 5 principles. Panchashil, they have said Panchashil. These are the Panchashil. Case based on circumstantial evidence has to be tested to the touchstone with Panchashil. And they have said that each circumstance has to be individually proved beyond reasonable doubt. Like if there are 2 circumstances, one is weak it can't take recourse to the other circumstance. Each circumstance has to be individually proved beyond reasonable doubt. They should form a complete chain, unerringly pointing out toward the guilt of the accused, consistent with his guilt, inconsistent with his innocence, and they should not be capable of getting explained by any hypothesis. Meaning thereby that the body was found in that lane and the accused prior to the incident was seen going in that lane, it becomes an incriminating circumstance. But if the accused explained that sir, मेरा घर भी तो वही लाइन में है, मैं घर पर जा रहा था, मैं डेली वो लाइन से जाता हूँ. So it should not be explained by any hypothesis. This is what the benchmark. Now in this judgment, they have said false defense is an additional link, not the basic link. Like if accused in circumstantial evidence trial is lying to the court, that can't be made basis as one of the circumstances. It is an additional link. Whichever the circumstantial evidence matter if you get, if you conduct a trial with the touchstone of this judgment, you can break the circumstances which incriminate you. You can strengthen the circumstance which supports your theory of the case, your defense, and you can convince the judge and the jury that sir, this is what the things are. Now once this case reaches to the stage of 313, last but not the least, one stage, the defense evidence. Rarely this right is exercised by the accused. In fact, there is no burden upon accused to prove his innocence. The burden always lies upon prosecution. But the ground realities are otherwise. On record, presumption of innocence is always in favor of accused, unless proved guilty. But practical when the terror charges are there, like Tada, Kota, Mapuka, the ground realities are different. An accused is presumed to be guilty unless proved innocent. Like under Mapuka, if the weapon is discovered, it is for organized crime syndicate. Under Tada and Kota, if some explosives are for terrorist act. So therefore, these special enactments, the presumption of innocence is otherwise. Burden is always upon the accused. Therefore, we should not lose sight of the fact that you have the right to examine defense witness in support of your case. Now, the defense witness may be on one fact, maybe on one circumstance, maybe on one piece of evidence, but you can't examine that defense evidence without giving an opportunity to the prosecuting witnesses to explain. Therefore, when working on this case, whoever the witness comes in the witness box, you must give suggestion, you must demonstrate. For example, for the charge of sexual assault under the POCSO, if the girl is of grown-up age, 17, 17 and a half, less than 18, above 16, etc., etc., and she complaints of sexual assault by force, by kidnapping, etc., 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 one-sided law affair, etc., and you have the evidence of telephonic conversation, you have selfies, you have WhatsApp chat, you have the evidence that she visited your house and visited the house of the accused and met the parents on a number of occasions. Now, once the evidence of that victim is over, you can't take the prosecutor at surprise. Once the evidence is over, and if you say that I want to rely upon this evidence, the question will be why you did not confront the victim. all these pieces of evidence which you have to rely upon the defense piece of evidence, you must put to the witness. Not when the case opens, but when the witness is in the box. So I'll give you an example. That was a very interesting case where the judge said, okay, I am of the firm view this man has committed murder. I am admitting him. I can't convict on morality. I have to convict on merits. Merits making officers tailored the case. The case was that a boy was teasing the wife of the accused. That was the case of prosecution. He was warned. He was not ready to listen. The case was that the accused purchased a chopper from the chopper seller, blacksmith. On the day the boy went on the Dobighat, he went there and killed. Gave multiple blows. The case was in the same chopper. He went to the police station. He says, I have committed the murder of so and so. The officer recorded a FIR of the very same accused in his name. He himself was the complainant. Chopper was seized, the clothes were seized, the CCTV footage of camera of the police, that was a piece of evidence. And he engaged me. I asked him, what is your defense? I said, sir, I have no defense. He said, you can't come out. Everything is against you. You are not the FIR against you. Recovery of weapon, the clothes stained with blood, telling with the blood of disease, and CCTV camera. How will you succeed? He said, sir, you defend. He said, I will try. I accepted the brief. I was discussing with one of friends. Now, I will give you the few facts. You have to apply your mind and understand what must be the in-between facts. I discussed with one of the most incriminating circumstances. 10 days back, I purchased the chopper. That witness is there. And he has given the receipt also. He may identify the chopper also. That shows that he has already had a motive in the plant. So he said that you can break it, it's very easy. How can he say that this is the very chopper purchase? This is not the chopper purchase. You can do it very easily. I understood. Now you have to understand it in between what must have. So the day of the evidence came, the witness was informed that he is the witness coming to the court. He came to the witness box, he said, yes, this accused purchased this chopper from me against this receipt. Sir, I am seeking permission to produce certain article. It was wrapped. That's it. Okay, allowed. The PP was possible, was not bothered. I gave a parcel. I said, please open it. Open it. It was containing a chopper. I said, this is the chopper. He said, yes. This accused purchased from you. Yes. Again, this receipt. Yes. Go. You understood? That chopper with blood stain, the case was that accused purchase. Now I proved before the court that no, that is not. This is not the chopper. It was lying in my house and that is planted one. They did not consider this aspect for acquittal. The acquittal point was this. The police case was that at 5:30 he lodged the FIR. He came along with the chopper, lodged the FIR. And immediately thereafter, up to 6:30, the chopper and the clothes blood stain were seized, taken charge. Now the station house footage was showing that this man was directly taken inside the police station. He was not seen halting near the SHO for lodging FIR. And while passing, the chopper was in the hand of policeman, eyes on his head. So the FIR was falsified. Now 6:30 they were showing it seizure. The perusal of the CCTV footage we played to the court. At 9:30 shows the policeman was moving with the chopper in his hand. So 6:30 his punchman was bogus, and 11 o'clock he was wearing the same cloth. So CCTV footage, his lodging FIR was discarded. One piece of evidence was that his mother said I saw, etc. But even she was not up to the mark in the cross. And that resulted in acquittal. Therefore, what is required before commencing a trial, you must go through the charge sheet and all other. one piece of evidence, CCTV, nowadays, the police, they have been, my learned friend has said that the new law has said the police has to record. I assure you, with this amendment itself, they will damage the case. This requirement of CCTV footage, whatever the Panchanama, etc., by this itself you can win the case. Because ultimately, you see, you have changed the law, you have not changed the mindset of the police officers. Now, earlier, whatever they used to do, now also they will do the same thing. Now, the Panchanama, it was impossible to find out where it was written, how it was written, by whom it was written, and on which date exactly it was written. But the CCTV footage you can find out. And believe me, I assure you, whatever they are doing with that, even with this, they will do the same thing. They will show the recovery of discovery first, but the event must have been shot on 6th or 7th or some other day. Just you have to find out on which date that electronic document came into existence. Every electronic record, when comes, it creates parallelly a property file. Every property file shows date and time of its creation and modification. So whenever the electronic record is there, like discovery, Panchanama or parade memorandum or squad Panchanama, etc., original footage in the pen drive or CD or hard disk, you have to open the property file, see the date and time of creation. If it doesn't tally with the Panchanama timing, meaning thereby one among them is a lie. Now the 65 certificate will be as per the timing of the Panchanama. Like for example, they are showing that article were seized on 1st under season Panchanama and was shot. The property file of electronic record shows it came on existence on 5th. Meaning thereby it can't be of 1st. Date of creation is of 5th. So एक तारीख का तो झूठा है. So केस डायरी एक तारीख का झूठा है, स्टेशन डायरी झूठा है, पंच झूठा है, ऑफिसर झूठा है. With this electronic record, and not about this, even about the incident also. Like ground reality. That's why I say you should know the ground reality. They are quite different from the practical aspect. मर्डर 1 तारीख को होता है 1 बजे, 1:30 बजे पुलिस के हाथ में सीसीटीवी फुटेज रहता है. If in any city, any town, any place, अगर रात में 1 बजे मर्डर हुआ, 1:30 बजे से 2 बजे के बीच में पुलिस के हाथ में सीसीटीवी फुटेज रहता है. विक्टिम कहां से है, किधर से गया, सस्पेक्ट्स, व्हाट वाज द रूट ऑफ फॉलोड बाय द सस्पेक्ट, एटसेट्रा एटसेट्रा, एंड ऑन दैट लाइन दे आर इन्वेस्टिगेटिंग. रिसेंटली यू मस्ट हैव रेड दैट वर्ली में एक स्पा ओनर का मर्डर हुआ. The murder was in the spa itself. Police were investigating. So, spa में पहले earlier he has gone for a party somewhere at Dadar. Spa was at Worli. Dadar he was having some drink, etc., etc. So police collected the footage. The footage, so they saw movement of 2 persons who were suspicious. The faces were not clear. Unfortunately for those assailant, and fortunately for the police, they saw one of the suspects purchase the gutka. But even that was not incriminating. While making payment to the gutka, he used the Google Pay map. Google Pay. That was shown in the footage. By Google Pay, they got the name, the number. They were apprehended from the other spot. But this is property file perusal. You can get the access. What exactly the date when it was created. You have to, and we have to work hard. We have to study the things. A stage will come in your life where you need not required to work so hard, but still for giving best performance, because someone is reposing faith upon you, he is giving his life in your hand, and he treats you as God, Bhagwan. He believes that perhaps you may save his life. His family members, ठीक है, whatever the circumstances, they believe that we are engaging a lawyer, He'll try his level best. He'll defend. Now, therefore, if for lapses on our part, lack of knowledge on our part, lack of time on our part, for our absence on time before the trial court, for our presence at the time of chief, for our loose cross-examination, for our open-ended question in cross-examination, for our act of damaging our own case by our cross-examination. If someone is getting conviction, I believe he is convicted not for committing the crime, but for lapses on the part of the lawyer. We must take care of it. Thank you.
Thank you, sir. We will give Sir a breather for about 5 minutes, requesting nobody to leave the hall. We will start with the last topic of the day, impact of the new criminal laws on cross-examination. Whenever Sir is ready to take the floor.
Sorry, I thought that my session is over. Impact of new laws on cross-examination. I am of the firm view, barring peripheral aspect, there won't be any impact on cross-examination. As I suggested, as I submitted, the legislature in its wisdom changed the law. They have not changed the police officers. With great respect, they have not changed the judicial officers. They have not changed the prosecutors. So appreciation is one and the same. Appreciation of evidence, appreciation of facts. दो और दो आज भी चार होंगे, कल भी चार होंगे. Truth will remain truth. Falsehood will remain falsehood. This law is not going to change appreciation. See, the relevancy and admissibility of facts is case based. The pieces of evidence is event based, investigation based. The law is not changing that. The law doesn't say now dying declaration is inadmissible. So if dying declaration is admissible, the cross-examination, you have the right. You have to decide the relevancy and admissibility of the questions, their sequence, etc. And the appreciation will be one and the same. If the dying man, while giving dying declaration, is not conscious where he is, with whom he is communicating, what is going on, he is given some intoxicated items, pain relief or something like that. Legally, said dying declaration is not admissible, they are not admissible. This law which they have changed, we are the advocate. Changing law is the prerogative of the legislature. See the ground reality. I just made an inquiry with my learned Mr. Prasad. He said the under trial pendency rate of session trial matters in Goa is around 4 years, 5 years. In Bombay, the same situation, 4 to 5 years. In exceptional cases, 8 to 10 years. Just visualize the ground reality. So, 4 to 5 years is the pendency rate. Next 5 years, we will be going with the old law. For those cases, this law is not changed, the saving clause is there. Now, after 5 years, verdict on either side, it is going appeal. That take further 4 to 5 years. For 10 years, this will be the law. At the Supreme Court, it takes further 4 to 5 years. For 10 to 15 years, this law, we have to be with this law. Now, see what sort of your cross will be affected with this. Yes, if the burden of proof is shifted, then perhaps it may affect the right of cross-examination. But even then also, by shifting burden of proof, your right is there, you have to cross-examine, you have to discharge the burden. Extra precautions required where the special enactment is there, like Tada, Pota, Makoka, UAPA, where presumption is in favor of prosecution, presumption is against the accused, where burden of proof is upon the accused, where certain piece of evidence which is not admissible otherwise is made admissible. Tada, its misuse, lot of even cry were made, therefore they abolished Tada, Pota was enacted, it was objected, it was abolished. Then Makoka. In Maharashtra, the Makoka, in Gujarat they got Gachkoka, and Delhi they got Takoka. Delhi Control of Organized Crime Act, where they have made confession before a hiring police officer admissible. But there also, your right of cross was never affected. It can't be. It is this right is internationally recognized. Only thing that, considering the severity of the charges, nature of evidence, you have to adapt with the situation. Like earlier, for CCTV footage, recently I got an acquittal on the CCTV footage itself. And my client were in custody for 5 years because of the CCTV footage. The case was that it was of Devnar police station, 3 friends, including one juvenile. They induced the victim for a party. All 4 sat on the bike, shot on the camera, went to a bar, had a drink, shot on the CCTV footage. The case was that they had a quarrel and then the man was unable to walk. He was forcibly dragged from the staircase. They said his earring was snatched. He was forcefully put on the bike, took him to a creek, threw him from the creek, he died. And later on, under separate discovery Panchnama, his gold chain was discovered. That was the case. I got an acquittal. I am of the view. I did not dispute that CCTV footage. Whatever incriminating aspect they were attributing to my client, I falsified that. I said, because there was no one, I said he invited for the party. Therefore we joined. That no one can dispute that. Because I was the only witness. The accused and the deceased were the only witness. They all 4 sat on the bike that was shot on the camera. They went to the bar. And the camera was showing they were consuming the liquor. There was no quarrel. So I admitted that. But when they said that we dragged him from the staircase first to the ground floor, hotel waiters were also helping. Actually, we did not drag, we slide him because he was quite bulky and hefty and he was unable to walk. When he was made to stand on the road, he fell down. We gave him the help. We were seeing the footage, we were searching. We said, he asked that he wanted to give tip. And he said, hold on, I want to give tip to the waiter. So therefore we were searching. We made him sit on the bike because he was unable to sit. And we said, in the creek, sir, he said that I want to urinate. Halt it or I will jump. We stopped. Parapet wall, he climbed. He fell down. This is what we admitted in the 313. Court has accepted. Court has acquitted. Now visualize the situation. If this Panchnama and all these things, these CCTV cameras are relied by the prosecution, the footage, etc. Appreciation is going to remain one and the same. If the footage shows certain aspect, apply your mind, see whether you can disprove that. As a defense lawyer, you have the right to challenge, you have the right to disprove by cross-examination. If you can't disprove, just think whether you can use it. Because by explaining those circumstances, you can use it in your favor. Even if that you can't do, you can reduce the gravity of the crime. In any of the eventuality, the cross-examination won't be affected. I personally believe that you must be using the four-wheeler car, and you know that after 4 to 5 years, and the lighter way, please take it, because we are lawyers, we can't criticize the legislature. That is the privilege of the political parties. When we are flying four-wheeler car, the front tire is getting punctured again and again. The puncture repairs will do one thing, sir, please you पीछे का टायर आगे डाल दो, आगे का पीछे डाल दो. The front should be more strong, otherwise it will be. That is what it has happened. I believe that is what has happened. आगे का पीछे कर दिया, पीछे का आगे कर दिया. Or we are using bedding nowadays. This company, that company, that comes with warranty and guarantee, but 10 years warranty, price is 30,000 for 10 years warranty. Okay, what are the guidelines? So the guidelines are that 3-4 months use करने के बाद just change it, turn it. You see, when we use a mattress, the bedding, तो 5-6 महीना सोने के बाद it affects body, dent आ जाता है उसके अंदर, it pains, we are required to go to doctor. The doctor says, change the bed, there is some problem. So the bed maker, they say, don't change the bed, just turn it. You turn it up and down or swing it. Guma also. It will be like a normal thing. If you see this amended law, what they have done, some subsections have been made a main section. Some main section have been made a subsection. Other than that, some provisions of special law, organized crime syndicate. It was first time introduced in Maharashtra. Now legislative debate are on record. It was to control the menace of organized crime. The gang war which was going on between two gangs, and to have the supremacy, they were running the extortion racket, and for that they were kidnapping, and upon failure to extort they were murdering. So control that managed this MCOC was enacted. Maharashtra Control of Organized Crime Syndicate Act. That was later on carried to other states also. So what they have done, some of the provisions which was already there, they incorporated the new amended law. Now Tada Pota Mapoka UAPA for remand, PC, JC, etc. Already it was of different duration, amended duration. 60 days to 120 days, 90 days, 180 days, 15 days remand, 30 days. Now Mapoka, this was already going on. Initial 5 days encash किया है, बाकी मेरे को और encash करना है, तो the judges used to say, okay, do one thing, go to the jail. I'll give a solid reason. So police custody gap, and again police, this was already there. There is nothing new to say that the right of cross will get affected. If they say, like in some portion, like in Jammu and Kashmir, there is a special law, Public Safety Act. Like Maharashtra, we are having MPD Act, Preventive Detention. There, the first hearing will be after 40 days or something like that. For final hearing of your writ petition, it may take 6 months, 8 months. So by that time, you have to remain in custody. But there, the right of cross doesn't come. They have the right of hearing. The hearing, they have their own time. It takes its own time. But the sum and substance is that this new law are not going to affect the right of cross-examination in any way. On the contrary, it has enlarged the scope of cross-examination. Whatever new they have introduced, we can cross-examine that level also. Thank you.
Thank you, Advocate Abdul Wahab Khan, for such a knowledgeable and insightful session. I'm sure all of us have learned a lot today about the new criminal acts in force. Thank you, sir. Well, I'm pretty sure that a lot of you have some questions, a few pointers before you all start with your questions. Kindly keep your questions brief. Do not get into any discussion with our resource persons. And yes, I think that's about it. So I have Nikhil to assist me. If anybody has a question, kindly
Anybody has
raise
a
your
question?
hand. Nikhil, ma'am, Tina. I think our resource persons have been crystal clear on their topics, so no questions at all. Now the students also. Okay, we have a question.
So, as we all rely upon the precedents upon each cases, how are these new acts going to affect the precedents which are our crux of our cases, sir?
The law precedents would continue to operate because as I said, most of the language of the section remains the same. So if, for example, 302 is now converted to some other section, 101 also, the law pertaining to murder would remain the same. So the change of law would not affect unless and until some new sections are sought to be interpreted where the applicability of this principle would be tested.
Thank you, sir. Would Advocate Wahab want to answer that question as well?
You see that these precedents, if they were on any particular interpretation of court enactment, that won't be applicable to new enactment because those wordings will not be there. Suppose some precedents were on the count of 15 days police custody or 30 days police custody, 90 days for the final report or 180 days for the final report. Same logic and interpretation would follow to the present. So I don't think that precedent, barring few, will affect the new enactment.
Thank you, sir. I hope that answers your question. Anyone else?
What would be the effect of preliminary inquiry conducted by the police before filing FIR or charge?
Position as it appeared before Lalita Kumari is restored. And even in Lalita Kumari there were exceptions made out, wherein they said that if it's a matrimonial dispute or a dispute of commercial nature, then police have a right to conduct a preliminary inquiry. It is in short a double-edged weapon, in the sense the police can narrow down and see for themselves as to whether actually an offense is made out or not. So to that extent, the introduction of preliminary inquiry is a laudable exercise. But on the flip side, as I said, it can be misused also. So it won't affect the FIR as such. It will only give a right to police to investigate prior to registration of FIR.
See this, now with this amendment, this introduction, they have legalized the illegality. Earlier also, the best police station was where the least crime rate. It should be the worst police station. The best police station award should go to the police station where the most crime rates are reported. Because it's not that the crimes are less reported, meaning there were no crimes. They are suppressing, they are hiding, they don't record it. Now this legalize that. Like in many cases, if you do survey for the sexual assault cases, when the victim party or the family member goes for lodging the FIR, practically they are trying all possible ways to delay it, to see that the matter is settled or sorted out, etc. That's the ground reality. For simple hurt or simple theft, they refuse to register the FIR. This is a ground reality all over India. None of the states is exception. Now this right to make an inquiry is additional protection given to illegally to the police. You know, one thing, they can refuse to register the FIR, and under the pretext of inquiry, they can kill the time. Ultimately, this will be detrimental to the case of the victim as well as the accused also.
Is there any provision for disciplinary action against the police?
But that's a law. We are advocate. We have to respect. We have to follow the law. That is the prerogative of the legislature. They have made the law. Unless the Supreme Court interprets like Lalita Kumari or some other judgments in a particular way, we have to go for literal interpretation.
One last question.
Regarding cross-examination, regarding the certificate given by an expert regarding electronic device, what would be the way?
This is 65B.
Yes, 65.
65B of Evidence Act.
Now it's changed regarding.
Changed.
Yes.
Now,
65.
you'll find only the nodal officer, their certificate is to certain extent perfect. Nodal officer. Because they are the qualified person, they are representing a company, they are the regular witness, they are the format. So they are just changing the mobile number, the other details, and issuing the certificate. So far as format is concerned, that format is perfect. But you will go to the format of others, like a society in the CCTV footage, issue the certificate, some technician, etc. Practically what is done is this, the certificate is drafted by the policeman. And if you read the content of the certificate, they are not certificate, they are the statement of the witness. The so-called 65 certificate, they are the statement of witness in so and so CR number, in so and so charges, I was called and I was asked, etc., etc. It's not with regard to authenticity. And keep in your mind, the basic purpose of 65B certificate is not for copying. Copying is one part. 65B is about authenticity and integrity of footage when actually it purported to have been recorded. That is what a 65B means. एक तारीख को 1 बजे घटना घटी है, उस वक्त जो शूट हुआ है, रिकॉर्ड हुआ है, उसका इंटीग्रिटी का 65B है. आपके मोबाइल का 65B मैं नहीं दे सकता, मेरे मोबाइल का आप नहीं दे सकते. Suppose I have shot certain events in my mobile, you can't certify. You can certify it's properly downloaded, but it was actually shot on the day which is shown in the mobile. You can't certify that. Therefore, if you see the wording in the 65B, 80% 65B certificates are weak in nature. They are not up to the mark. They are defective. They are just a statement, like 160 police ने statement लिया है. वो 160 statement का title के अंदर जो है 65B पुरावा लिखने का subject नीचे signature लेना stamp seal, that's all. Contents are like 161.
Thank you, sir.
One question with regards to nodal officers. Recently there was a witness in an NDPS case whereby a nodal officer had come to depose. So what he had said that he is not the only person who had access to the main server. So there were many other nodal officers. So now what is the position with regards to 65B certificate in this case? Because the only person who has authority over that information can give a 65B certificate.
65B for nodal officer. The first and foremost, these companies are multinational companies, operate all over India. They have their offices in different states. Server is common. state-wise nodal officer is appointed, and all the nodal officers all over India have access to the server. So even if some mobile was in communication at Delhi, Bombay nodal officer can use 365 certificate from downloading from the server. So nothing wrong in that. One thing. So this suggests that all were having password, etc., and it was accessible. But very surprisingly, this CDR runs in 100 pages, 1000 pages. It is never cross-checked. If you ask the nodal officer, and I asked and they were admitted, they never cross-check before issuing the certificate. Meaning thereby, अभी 1000 page का CDR निकाला उन्होंने. So each transaction they did not cross-check in the system. They presumed it's a proper replica. One thing. अब जो nodal officer जो है in a criminal trial, first and foremost, what is the importance of that CDR? वो मोबाइल किसके नाम पे है, कौन से ट्रांजैक्शन रेलेवेंसी है, एंड कैन यू एक्सप्लेन दैट रेलेवेंसी, दैट ट्रांजैक्शन, दैट्स इंपॉर्टेंट. 65B में जो सर्टिफिकेट नोडल ऑफिसर का होता है, तो नोडल ऑफिसर नेवर एक्सप्लेन व्हाट वाज द कन्वर्सेशन. दैट्स इन योर हैंड एज अ डिफेंस लॉयर. If you can explain, sir, this was the conversation, you have to see whether that can be disputed or believed. If two witnesses say this was the conversation, no one can dispute that. Thank you.
Thank you, sir.
Sir, can you enlighten us on trials in absentia that new what has come?
So as I said, कि 4-5 साल पुरानी गाड़ी हो गई तो जस्ट टायर उसका आगे पीछे कर दो या बेडिंग है, वो एडवाइस दिया है फॉर स्ट्रेंथनिंग लाइफ. इट वाज ऑलरेडी देयर. 299 CRPC इज देयर. नथिंग न्यू. उसको राइट ऑफ क्रॉस एग्जामिनेशन भी है. अगर इफ यू आर सो कॉम्पिटेंट, देन मेक अ लॉ, ट्रायल, conviction and execution in absentia, like in some countries, like in Pakistan, some other countries, Middle East countries, etc. If accused is absconding, they will conduct the trial in absent, they will hold him guilty. जब भी मिलेगा उसको execute कर देंगे. You can't make such law. It is not internationally recognized. Trial in absentia, these provisions are already there under 299 of CRPC. If someone is absconded, jumped the bail, not likely to be arrested in the near future, and by the time he will come before the court, the evidence is likely to wash away. With proper evidence in the record, court can record that evidence to see that it is preserved. Whenever he is arrested, if the witness is available, if he asks for cross, his right can be respected. And suppose the witness is expired or some sort of medical problem, he can't come, then the accused cannot take advantage of his own wrong. That's what the thing is. Nothing.
Thank you, sir. With this, we complete the question and answer round. I hope that all of your queries have been sufficiently answered. I thank our resource persons for the morning, for your insightful knowledge and imparting all that you all have practiced in these years towards us. As a token of our appreciation for taking the time out to grace us with your presence and for imparting your valuable knowledge and experience to us, I request our Sangya member of the association, Advocate Kashna Desai, to kindly present a memento to Senior Advocate Anil Madhukar.
Thank you, Advocate Kashna Desai. I now request Advocate Nikhil Katkar, the South Goa Advocates Association Margao member, to kindly present the memento to Advocate Abdul Wahab.
Ladies and gentlemen, I think we've been a bit stingy with our clapping because our resource persons definitely deserve a louder applause than that. Thank you so much. Thank you, Nikhil. As we have come to an end to the seminar and a truly insightful and splendid morning spent amongst wonderful people, I request Advocate Rohit Shirodkar, the Secretary of our association, to kindly propose the vote of thanks.
Senior Advocate Mr. Anil Madikar, Advocate Abdul Wahab Khan, and my dear colleagues. On behalf of the South Goa Advocates Association, it's my honor to deliver the vote of thanks. First and foremost, I would like to thank our distinguished speakers, Senior Advocate Anil Madikar and Advocate Abdul Wahab Khan. Your expertise and insights have not only enlightened us, but also challenged us to think critically about the new law and its far-reaching effects. Your dedication to advancing understanding is truly commendable. I would like to thank the chairman of Rabindra Bhavan, Sri Rajendra Talak, and the entire staff of Rabindra Bhavan for their support in organizing today's interactive session. A special thank you to my committee members who have worked tirelessly behind the scenes to ensure that the seminar was a success. Your hard work, attention to detail, and commitment to fostering the space for meaningful discussion have made today possible. Finally, I must not forget to thank our compares for today's session, Advocate Ann Furtado and Advocate Palamantao. Thank you once again, and I am looking forward to continue these important discussions in future. Thank you so much.
Thank you, Rohit. Then a last round of applause to the South Goa Advocates Association for yet another excellent event. Thank you, everyone.